All right, this is part 2 of the part 3 pro se party series. The first video I talked to you guys about the important deadlines, and for this second part of the pro se series, I want to talk to you about just some general tips on how to survive a court hearing. The first thing is that you want to read your case management order or your pre-hearing order so that you understand all the procedures and what the court's expecting of you. You also want to key into the idiosyncrasies of your particular county, in particular your judge. Figure out what kind of, what is this judge like in the courtroom? Are they the type that's going to keep really strict time? Are they a little more lax? That's important information to find out, and you can learn that by asking their clerk. You are probably going to have questions about different procedures in general, and they might not be appropriate for the division clerk, and so I would suggest that you speak with the family court facilitator. You should breeze through the rules of evidence. Obviously, you don't need to memorize them, but it's nice to have a handle on just the general rules of evidence. Then you need to figure out how much time that you have, and be prepared to keep track of all of your own time. Prepare your presentation of evidence to be as brief as possible. Next, you want to start getting prepared with your evidence well in advance. You don't want to be scrambling at the last minute. And when I say prepare, I mean figure out your witnesses and what information they have to offer that's useful. What are your exhibits? Are they going to be admissible? All of those things. And then additionally, your position statement or your argument. So do that in advance. Like I said, you don't want to be scrambling. Then you should confer with the other side, either the other party or the other attorney, and figure out if there's any agreements. They're called stipulations about different exhibits and or the order of witnesses. It can be really helpful and save time the day of your hearing. Next, when you get into the courtroom, you want to be calm, you want to be prepared, and you want to be respectful. Be respectful of everybody, especially your ex. I know it's emotional, but do not let your emotions get the best of you. And then finally, in your remedy and your request for relief, be specific, be concise and clear about exactly what you want the court to order, and also explain why the judge can legally give you what you want. That's it for part 2. I will see you in part 3.